Hey everyone, and welcome. If you're a law student or gearing up for the bar exam, you are in the exact right place. Today's explainer is a comprehensive study guide designed to help you completely master one of the most highly tested and honestly deeply fascinating areas of torts, premises liability. We're going to break down the exact black-letter rules for duty and negligence that you absolutely need to know. Let's get right into it. Here's our roadmap for today. We'll start with the two premises liability frameworks, then look at common law status categories, followed by dynamic shifts and exceptions. After that, we'll cover the attractive nuisance doctrine, move into the unitary approach, and wrap up with landlord and off-premises duties. This structure is going to organically guide you from the rigid, historical common law rules straight through to the modern negligence standards. All right, Section 1, two premises liability frameworks looking at the borders of the legal landscape. Okay, let's dive into this overarching battle between traditional property-centric law and modern negligence principles. Now here is a massive exam tip right off the bat. The categorical status framework is the majority rule. If you're writing a standard law school essay, this is absolutely the framework you must apply first. It's rooted way back in feudal history, and under this approach, the duty owed to someone depends entirely on their specific classification at the exact time of the injury. On the flip side, we have the unitary approach. This is a distinct minority rule, famously championed by California, that just tosses those rigid classifications right out the window in favor of a broad, uniform standard of ordinary, reasonable care. Moving right along to Section 2, common law status categories, or the hierarchy of entrants. Since the categorical approach is the majority rule, we've got to start there. Under this traditional approach, a plaintiff's label literally dictates their legal worth. Think of this matrix as your ultimate cheat sheet. It breaks down exactly how duties escalate based purely on an entrance classification. Down at the bottom, you have trespassers. They're owed the absolute lowest duty. In the middle, you've got licensees, who get a moderate duty. And at the top, invitees. They command the absolute highest duty of care. Let's unpack these. So an invitee is someone like a customer shopping at a grocery store or maybe a visitor at a public museum. For this class of entrants, you've got to remember that a simple warning is often not going to cut it. Landowners actually owe an affirmative duty here to actively inspect their property, discover any hidden dangers, and fix them to make the premises safe. Next up, the licensee. Now, this one always trips people up. So the crucial point is that your friends and family, your invited social guests, are actually just classified as licensees under the law. They are there for their own personal benefit, not to make you money. For a licensee, the landowner has absolutely no affirmative duty to go hunting around for unknown defects. The duty is just to warn them of known hidden dangers that the guest probably wouldn't notice on their own. That brings us to Section 3, dynamic shifts and exceptions, focusing on fluid status and discovered perils. Listen, if there's one thing bar examiners absolutely love to test, it's the fact that legal status is not static. A plaintiff's classification can literally change in a heartbeat based on geography, time, or how the parties interact. And this quote brilliantly illustrates the concept of geographic scope. Think about the Ohio Supreme Court case, Gladden v. GCRTA. A man bought a train ticket, which immediately made him an invitee. But after being chased and beaten up on the platform, he ended up down on the actual transit tracks. The court held that because he exceeded the permitted area of his invitation, he instantly lost his high-level invitee status and became a trespasser. It's a harsh reality, but under common law, even an accidental trespasser is still just a trespasser. Let's walk through a super practical hypothetical to really cement how shifting interactions transform these black-letter rules. Imagine an unsolicited salesperson walks up to your front porch. They have implied permission just to knock, right? So they start as a licensee. Now, if you buy a magazine from them, giving them an economic benefit, their status immediately shifts to a business invitee, and your duty elevates. But let's say you yell at them to get off your property. Boom. They instantly become a known trespasser, and your duty drops significantly. But hang on, there is a vital exception you've got to know, the discovered peril exception. Even if someone is a trespasser owed the lowest possible duty, the exact moment they are discovered in a position of peril, the duty elevates. Going back to that Gladden train case, the transit authority's duty suddenly escalated to ordinary care, the precise second the train operator looked down the track and discovered the plaintiff's tennis shoe sitting in the path of the train.
All right, Section 4, the attractive nuisance doctrine. As you can guess, the strictness of the common law can cause some incredibly harsh results, especially when kids wander onto someone's property. This basically forced the courts to carve out humanitarian exceptions.
You absolutely have to memorize these 6 explicit requirements of the attractive nuisance doctrine from the restatement. A tragic but perfect example is the Bennett case. The defendants had an abandoned, unfenced swimming pool that had basically turned into a murky pond full of frogs. A 5-year-old child trespassed just to look at the frogs, fell in, and drowned. The court applied these exact elements to save the child's claim, ruling that landowners do owe a duty of reasonable care to child trespassers if an artificial condition poses a highly foreseeable risk that a young kid just wouldn't comprehend.
What makes that Bennett case even more heart-wrenching is that the child's mother also drowned while trying to save him. The defendants actually tried to argue she was just an adult trespasser, but no, the court applied what's called the rescue doctrine. Because the mother was attempting to rescue her child from an attractive nuisance, the law says she legally assumed the status of the child. Because of that, she was owed the exact same elevated duty of ordinary care as her 5-year-old son.
Okay, Section 5, the unitary approach. This is where we tear down the feudal walls. We are entering the climax of our legal narrative here. What if we just threw out this entire complicated categorical system? Well, that is exactly what the California Supreme Court decided to do in the landmark 1968 case, Roland v. Christian.
I want you to really chew on this Socratic question for a second. In Roland, a social guest, who, remember, is just a licensee, severed the tendons in his hand on a cracked bathroom faucet. Under the old traditional rules, winning his case was incredibly difficult because his host didn't actively hurt him. She just failed to warn him of a known defect. The court looked at this whole setup and basically asked, wait, why does this guy's life have less legal value just because he isn't a paying customer?
Let's look at how this builds a completely new legal framework. In California, and a minority of other jurisdictions that followed, they replaced those old feudal labels with a modern balancing test focused on human safety. Instead of asking if the plaintiff was an invitee or a trespasser, the court now looks at these 7 specific Roland factors. They use them to determine if the landowner acted as a reasonable person would in managing their property. It is a massive, fundamental shift from property rights over to human safety.
Finally, Section 6, landlord and off-premises duties. Before we wrap up, we need to cover 2 very specific, highly tested nuances: landlord liability and what happens when an injury occurs beyond the actual property line. A core rule to remember here is that premises liability usually falls on the person in actual possession of the land, like a renter or a tenant, not necessarily the absolute landowner. Because the tenant is the one in possession, landlords are actually incredibly insulated from liability. For your exams, you must know that a landlord is generally not liable unless they trigger one of these highly specific exceptions. If an injury happens in a common stairwell, or because of a hidden defect the landlord actively covered up before the lease started, or maybe because the landlord did a terrible job fixing something they volunteered to fix, then, and only then, is the landlord on the hook.
And what about folks outside your property line? Well, if you create an artificial condition, like a mining operation that leaks toxic runoff, you absolutely owe an active duty of reasonable care to your neighbors. But if it's a natural condition, like rainwater flowing down a natural slope onto your neighbor's land, you generally owe no legal duty at all. However, there is a super fascinating strict exception: trees. Trees are the rare natural exception. If you have a rotting tree on the edge of your land, you must use ordinary due care to inspect and manage it to protect passing pedestrians and neighbors from falling branches.
So here is the final thought I want to leave you with as you continue outlining. This battle between the traditional majority rule and the unitary minority rule is really a battle of legal philosophy. Which system do you think serves society better, predictability or flexibility? Keep analyzing these concepts.